Discharge of surety. A surety is said to be discharged when his liability comes to an end in following ways. By revocation, notice, death, novation. By creditor, variance in terms of contract, release or discharge of principal debtor, compounding by creditor with principal debtor, impairing rights of surety, and severance of security. By invalidation of contract, misrepresentation, concealment, joining of co-surety and consideration. Discharge of surety by revocation. Notice, a specific guarantee cannot be revoked by the surety if the liability has already accrued. The surety may revoke a continuing guarantee by notice to the creditor as to future transactions, but remains liable for past transactions. Death. On death of the surety, his estate will not be liable for any transactions entered into after his death, but his estate will be liable for contracts entered into prior to his death. Novation. When a contract of guarantee is substituted by a new one called novation, the original contract of guarantee comes to an end. Discharge of surety by creditor. Variance in terms of contract. When the terms of contract between the principal debtor and the creditor are varied without the surety's consent, the surety is discharged in respect of transaction subsequent to the variance. Where the guarantee is for the performance of several distinct duties or obligations or for the payment of distinct debts, a variance in the nature of one of them will not discharge the surety as to the rest. Where the guarantee is a continuing one, any such variance will discharge the surety as to the transactions subsequent to the variance. Discharge of principal debtor. If the creditor discharges the principal debtor, the surety is discharged. If the principal debtor is discharged by an act or omission of the creditor, the surety is also discharged. Creditor compounding with debtor. The surety is discharged when the creditor and the principal debtor, without consent of the surety, makes a composition or promises to give time to or not to sue the principal debtor. Impairing rights of surety. The surety is discharged when the creditor does any act which impairs the remedial rights of the surety. Severance of security. If the creditor, without the consent of the surety, parts with any security given to him at the time of contract of guarantee, the surety is discharged from liability to the extent of the value of security. If there are two or more debts each secured by separate security, the surety of one of the debts is not discharged if the creditor parts with the security relating to other debts. Discharge of surety by invalidation of contract. The surety is discharged in respect of guarantee given in the following cases. Misrepresentation. Any guarantee which has been obtained by means of misrepresentation by the creditor. Concealment. Any guarantee which the creditor has obtained by means of keeping silence as to material circumstances is invalid. Joining of co-surety. Where a person gives a guarantee upon a contract that a creditor shall not act upon it until another person has joined in it as co-surety, the guarantee is not valid if the co-surety does not join. Consideration. The surety is discharged in case of lack of consideration between creditor and the principal debtor. Surety not discharged. The surety is not discharged in the following circumstances. Grant of time. The surety is not discharged where the creditor makes an agreement with the third person to grant time to principal debtor. Creditor's forbearance to sue. In absence of any provision to the contrary in the guarantee, mere forbearance on the part of creditor to sue principal debtor or to enforce any remedy against him does not discharge the surety. Operation of law. Surety is not discharged by operation of law. For example, omission of the creditor to sue within the period of limitation.